lecture. I hope you have opened your notes. So we will first embark on AS levels. Second chapter, we have already completed chapter 1 as our demo lecture. You can see that today we will be studying about what green and white papers mean. What are these two things? So, whenever the legislative process starts, there are a couple of steps to it. Some steps are mandatory, meaning they will be fulfilled by the parliament or the body that is performing the legislation, while in some cases, some steps are selective, are not compulsory, are recommended, or sometimes adhered to by convention by the parliament. Such steps include the green paper and the white paper stage. So, what is a green paper? Let us study it a bit more in detail. The opening remarks state that lawmaking can be initiated through a myriad of means, but it will be initiated. It is a research problem, basically. And in order to identify a problem, you have to look into the society that the parliament exists in and try to identify what things need redressal or what things are to be considered by the lawmakers. In this particular case, it is some problems that are being noticed by academicians, by lawyers, and by retired or senior judges, which are addressed by the green paper societies. So lawmaking can be initiated through a myriad of means. The important factor to consider is that the parliament is the representative of the people and by the people, and it works in order to benefit the maximum number of these people. So basically, the British Parliament will work in order to satisfy the maximum number of citizens of the United Kingdom and to benefit the maximum number of citizens of the UK. To accomplish this end, the UK Parliament works very hard to indulge in legislative function. They will not just dive into the process, they will first stop, look, listen, identify the issues that are plaguing society or the shortcomings of an existing law, perhaps even conduct some research, do some surveys, and then, after they have actually identified a problem, they will proceed in a manner to fix that problem. The steps taken to achieve these ends span green and white papers, which the Parliament uses to gather information regarding pressing legislative issues. So, what is the Green Paper? The Green Paper serves as a pivotal initial document in the legislative process. The aim of Green Papers is to actually gather the following. That is, first of all, it will initiate, spark, or actually benefit from discussions that are already taking place. For instance, law professors, researchers and research fellows will be working on pressing legal issues, publishing reports, publishing conference papers, and even cold hard theses in their masters and in their PhD studies, and they will work hard to identify gaps that are left by legislation or unintended consequences that have come to the fore, which nobody could reasonably have foreseen. So the Green Paper actually aims to gather these discussions, these informed discussions, basically, and to gather the feedback. Now, this feedback can be from the legislative bodies, that is, the people. It can be from the public at large. It can be from retired judges. It can be from influential lawyers, the bars, etc., because they actually have a very strong view on what is happening and shape policy proposals accordingly. They play a crucial role in seeking public and expert opinions on specific policy areas or proposed legislation before formal drafting. Their effectiveness lies in stimulating debate, exploring policy options, and shaping subsequent legislation based on comprehensive consultations. So basically, green papers are scientific and technical consultations which are available to the parliament in the form of a green paper. Green papers resulting in legislation. There now we have some examples of green papers that actually matured into practical legislative steps. The Children Act of 1989 was a green paper initially. The child protection messages from research preceded this act. It aimed to overhaul child protection laws, emphasizing the welfare of children and the need for a structured system ensuring their safety and well-being. Secondly, is the Freedom of Information Act 2000, preceded by a green paper. This act focused on promoting transparency and openness in government. It sought to grant public access to official information, enhancing accountability and trust in governmental functions. Another example would be the Land Registration Act of 2002. The Green Paper preceding this act aimed to modernize land registration laws. It addressed the complexities of land ownership, seeking to simplify the process and enhance accessibility on land registration records. This is a very pressing issue, actually. This is a recurring issue throughout the world, whether it be the Netherlands, the United Kingdom, or Pakistan, or even India. So basically, land registration, keeping land records safe, to keep land record from being manhandled and to be illegally amended by the people who are in charge of it is a challenge. So this is always a running problem. And yes, green papers are a perfect method of actually addressing issues relating to these esoteric fields of the law. The Mental Capacity Act of 2005 was initially a green paper and it eventually matured in Parliament as a bill and became law. The Companies Act 2006 was of a similar stroke. The Companies Act actually deals with how companies are formed, how they will be dissolved, who will be in their boards, and what is the nature of a company, and how it can be treated, and how the corporate veil, the veil that actually safeguards the directors and the office holders of the company from direct prosecution, all of these things were addressed through a green paper because we had a lot of accountants, corporate professionals actually contributing to the nuances and the intricate things available to it. Expert consultations are held whenever a green paper is being formed. Expert consultations within the context of green papers play significant roles in shaping legislation and policy formation. Expert consultations yield the following useful insights for us. First of all, we get an in-depth analysis and insightful contributions regarding a very specific, substantive, and specialized field that the law aims to address. An example of these would be the legal field. It might be something related to economics. It might be a sociological issue that needs addressing. It might be a matter of public health policy. It might also be something related to the environmental sciences and how emissions laws, as we see today, that the UK is trying very hard to cut down on carbon emissions and how people can burn things or not burn things. So basically, all the laws relating to these fields would be the most effective if they actually came in from green papers. And various industries provide comprehensive analysis and insights. Their contributions delve into intricate details, potential implications, and the broader societal impact of the proposed legislation. For instance, legal experts can identify loopholes or ambiguities within the law, while economists can assess the financial impact and feasibility of proposed measures. An example of this would be currency control measures, whether a bank should be regulated in the manner that the parliament is thinking about, or should it be given some other treatment? Those things would be better assessed by a person who is well versed with economics and financial policy rather than just the law. A combination of both will be required to be as effective as possible here. Because remember, students, that the basic purpose of the law is not just to throw a piece of legislation out there and to start enforcing it. Rather, the job of the parliament and the law itself is to help people, it is to serve the people and to keep them safe and to keep their daily daily interactions as profitable and predictable and certain as possible as can be. Research and evidence-based input. Experts bring forth empirical research, case studies, and evidence-based data. So basically, the parliament won't be just shooting off into the air. They would actually be working along research-enhanced lines. Value would have been added to that legislative process by making sure that they had the right data to make the decision. These substantiated arguments and findings contribute to a well-informed discussion around policy options. For example, the context of environmental legislation, scientists might present data highlighting the urgency of climate change, aiding in the formation of robust environmental policies. Critical evaluation and recommendations. Through their specialized knowledge, experts often offer critical evaluations of the proposed policies, identifying strengths and weaknesses and potential unintended consequences. For instance, I am a lawyer. If I start making environmental policy, if I start stating that a particular chemical must be disposed of in a certain way, that would be unreasonable of me because I am not a chemical specialist. I'm not an expert in the field. I'm not a chemist. I'm not a chemical engineer. I'm not an environmental management scientist. I do not know the intricacies of that process. I will, however, be there on hand to draft things, to propose controls, and to propose legislative structure. But the nitty-gritty of it, the tiny morsels that must be considered and chewed before the law is made, will be from the experts themselves. They may also suggest amendments or alternative approaches contributing to more effective, balanced legislation. For instance, healthcare professionals might offer insights into improving healthcare policy implementation and care standards. Diverse perspectives and stakeholder engagement. Expert consultations ensure the inclusion of diverse perspectives. Engaging experts from various sectors and interest groups foster a holistic understanding of the proposed legislation's implications. This in practicality helps to broaden the scope of the discussion. We learn much more than we would have alone. We are able to produce very impactful and powerful pieces of legislation as a result, considering differing viewpoints and addressing concerns from multiple stakeholders. Policy development and public discourse. Expert contributions drive informed policy development. Their involvement supports policymakers in crafting legislation and that aligns with best practices, ethical standards, and societal needs. Moreover, the dialogue between the experts and policymakers creates an opportunity for public discourse, increasing transparency and accountability in the legislative process. In the concluding remarks for Green Papers, we can see a quote by Sir Geoffrey Jowl, renowned for his expertise in constitutional law. The professor said, the role of Green Papers in initiating public debates on policy matters was very important. He emphasized that these consultation documents serve as catalysts for discussions, enabling citizens, interest groups, and experts to engage in meaningful dialogue, thereby contributing to the democratic process. And here, Green Paper stops. We will proceed to the White Paper now. Okay, so we begin with the white papers now. White papers in the realm of British legislative procedures hold paramount significance, serving as foundational documents that articulate proposed policy changes or introduce potential legislation. There is a significant difference between white papers and green papers. We must remember this. For green papers are mostly just discussions. They are pooling together the thoughts of all those people who are the stakeholders or who matter in a particular situation. White papers are not this way. White papers are far more specific, they are more in depth, and they actually define the blueprint for legislative change that is to be enacted by the parliament. Structure and nature of white papers is discussed as follows. Unlike green papers that present ideas for discussion and consultation, white papers provide comprehensive plans for policy implementation or legislative reform, structured into sections and chapters. White papers follow a clear format presenting the following things. There will always be a background and context. These documents commence with a thorough introduction. They will outline the historic background, the data that is being used, how things are being modeled, and how solutions can be inferred from these. Issue analysis will be present in the white paper. White papers delve into the detailed analysis, providing statistics and how it actually extracted the data and how it came to a particular conclusion. Proposed solutions. They offer comprehensive strategies, policy changes, or legislative recommendations intended to resolve the identified issues, often highlighting the government's proposed approach. Policy objectives. Clear objectives and expected outcomes of the proposed legislative changes are also articulated in the white paper, unlike the green papers. Consultation mechanism. White papers include a plan for consultation, which will invite further public opinion and input on the matter, and will invite all the stakeholders to actually read the white paper and to comment on it so that Parliament can get to the meat of the problem very quickly. Impactful legislations that have originated from white papers. The Education Act of 1944 started out as a white paper and then later on yielded into a proper full-scale law. The Race Relations Act of 65 was guided by a white paper. This aimed to tackling racial discrimination, advocating for equality in public places and services. The Consumer Credit Act of 1974, a white paper paved the way for this act, regulating consumer credit agreements and enhancing consumer protections, which were not very forthcoming before this. The Housing Act of 1980, preceded by a white paper. This act introduces right to buy, allowing council tenants to actually purchase their homes. Now, council housing, guys, we need to understand what this is. Council housing is basically housing provided by the British state to the people who cannot afford to get a mortgage or to buy their own house have to apply to the government. The government actually has a waiting list upon which it accommodates people into council housing, giving them a roof over their head. This act actually enabled those people to transition from tenant to owner, thus slightly lifting them out of poverty. Freedom of Information Act 2000. Based on white paper, this act established the right to access information held by public authorities. Now let us discuss some juristic and scholarly views on what white papers are. Lord Bingham stressed the importance of white papers as detailed policy frameworks that guide the legislative process by presenting specific proposals. These insights underscore the instrumental role of white papers in shaping the legislative discourse, fostering public engagement, and contributing to the formulation of effective legislation that aligns with societal needs and government objectives. So basically, we can see from the very beginning that green papers, though not very specific, not very, how shall we say, solution oriented, though they do provide solutions, but they are not as final and they are not as structured as white papers. We will see differences between the two and how both impact legislation in their own way in the following table. So, where purpose is concerned, green papers actually aim to ask the people to gather opinion only. It is the opinion, sometimes it's existing opinion that is enhanced upon and worked upon, and sometimes it will be a call for information. However, in white papers, it is proposed the specific policies and solutions are hereby proposed to be this way. The level of detail, uh, green papers will not be as detailed. There will be broad discussion points. There will be thoughts of experts on the matter, but it would rarely be specific. White papers are not this way. White papers are properly structured. and highly detailed, and they will outline the very problem and the exact solutions that are proposed in order to resolve that problem. Structure. Green papers usually are structured. However, they can be open-ended and sometimes they might lack too much structure. However, white papers will be like any other paper. They'll have an introduction, they'll have a title, they'll have an index of the resources and the documents being used in preparation for that white paper. It will be a proper publication for all intents and purposes. And it will draw out and state specific plans and will have chapters and sections that address specific things. Function, stimulate, green papers aim to stimulate debate and discussion, while white papers are formed on the basis of those discussions. And from the basis of those discussions, they actually propose legislative points that need to be incorporated into the law so that it can be more effective. Consultation focus of green papers is wider and more exploratory because we don't know about the exact nature, the extent, and the span of the problem. However, when a white paper comes around, we have completed this stage that we have, it means mostly that we have completed the green paper stage, and now it is time to become more specific, to have narrower considerations, and to proceed accordingly. And as to outcomes, green papers may or may not lead to legislation. However, white papers may result in legislation or formal action. And here, white papers end. Please let me. So now we will study about the British Parliament, how it starts its legislations. We have already studied about green papers and white papers. Now it is time to actually see how the British Parliament functions and how laws are enacted by it. So first of all, let us study the structure of the British government. The UK Parliament stands at the center of it. The UK Parliament has three main functions. That is, it will make the law. It is the chief legislative body of the nation, of the state. It is sovereign, and it may make any laws that it pleases. To make law, Parliament passes laws by which the country operates. Secondly, it will provide a forum in which the actions and policies of the government may be publicly scrutinized. How does that happen? Well, you directly vote for the MPs that sit in Parliament in the House of Commons, while the House of Lords provides oversight and scrutiny as a permanent house. Thirdly, to deal with public finance, the government raises money by acts of Parliament. It is the job of Parliament to actually budget, to create financial institutions, to regulate said financial institutions, and to ascertain an annual working budget of the United Kingdom. Now, what is the Parliament? What are the parts that make up this massive institution, this ancient and highly respected institution of the United Kingdom? Well, it is composed of three branches of the government. The first would be the House of Commons, the House of Lords, and the Queen. It is a triangle of sovereignty with the Queen or the Crown being at the head of it. At the time these notes and the book were published, basically, Queen Elizabeth was among us. Therefore, it is termed here as the Queen. Currently, King Charles, her son, is on the throne of Britain, and he will be the King of Britain. So basically, it holds the crown at the top of the triangle or the pyramid, with the House of Commons and the House of Lords serving underneath it. The House of Commons and the House of Lords make up the two houses of parliament. It is a bicameral legislature. If you wish to write this down, you may. It is a bicameral legislature, meaning that it has two stages. It has the House of Commons, the popular house, while the House of Lords is the appointed house. It cannot be elected directly. People enter this house either by peerage or appointment. What is peerage? Basically, the barons of old and the lords of old from the peerage, they inherit their title from father to son and now from father to daughter. And they would go ahead and actually sit in their ancestors' place, while the appointed lords, such as an example would be, I've heard that he has been disgraced because of some incident. However, he was a lord at one time. Lord Nazir was a very good example of this. He was appointed by the British government for rendering extraordinary services to the United Kingdom and its Pakistani and Kashmiri population. So there will be a lot of people like that entering the House of Lords as well on special lists recommended by the Crown itself to be there. Under normal procedure, both houses must vote in favor of a bill before it can become a new act of parliament. So, if a law must be made, it must be discussed and voted on by both houses of parliament successfully. Only then can it proceed to becoming a law. Why does the UK have two chambers of parliament? It is a bicameral legislature, meaning it has a popular house and an upper appointed house. It is to maintain a balance of power. Both the houses actually keep a check and balance on each other. They check each other's power and they keep an eye and tabs on the members of each of these houses so that there is very little chance of somebody just coming right up and becoming a dictator. The House of Lords is an independent group that can send the bills back for amendments, but the power to reject a bill of the Commons does not belong to the House of Lords. This is a more modern thing. Before, the Lords could significantly impact legislation. However, in today's time, legislation may be impacted uh, by the a House of Lords. However, the House of Lords may not indefinitely stop legislation from being released by the House of Commons. The House of Commons still has more or less an authority and sovereignty where bills are concerned. In theory, the most important of these bodies is the Queen. In practice, however, the real power lies with the House of Commons as the only directly elected body in Parliament. Most legislation originates from the government and is introduced first into the House of Commons, where it is known as a bill. In certain circumstances, the Commons has the power to legislate without the consent of the House of Lords, but the converse situation does not apply. The House of Lords used to have the power to veto any bills. This is not so because of the Parliamentary Reform Acts, which we will study later on. Especially regarding finances, the House of Lords does not get a say in the lawmaking process anymore. So this is a diagram of the basic functioning of the UK governmental system. As you can see, the Crown is at the head with the legislature, that is the Parliament, including both its houses, at the very right hand of the monarch, with the executive, that is the Prime Minister's office, at the left, and the judiciary, the judicial pillar of the government, being on the extreme left of the monarch. As we can see, the legislature is further split into a bicameral system, that is the House of Commons, which is the political house or the popular house, which comes through direct voting, while the House of Lords is a semi-political or appointed house. The executive consists of the Prime Minister and their cabinet. It is politically elected. They are always members of the House of Commons now, and ministers and civil servants report to the Prime Minister and his cabinet and his government. The judiciary represents the Supreme Court and the Court of Appeal, respectively. Now, how would a process in Parliament begin? Whenever a bill is introduced in the Houses of Parliament, if it is introduced in the Commons, bill will start in either the House of Commons or the House of Lords. It can be both the houses. There's not an issue unless it's a money bill, in which case the Commons will have exclusive right to deal with that bill. A bill would be subjected to the first reading, that is formally introduced. The formal introduction of the bill is conducted in any of the houses where it was initially introduced. If it's the Commons, it will be read out in the Commons. If it was the Lords, it will be read out to the Lords for their benefit. The initial reading will read out the brief title and briefly explain the contents of the bill and what it proposes to do. There won't be any debate at this stage. However, only a slight reading would be considered relevant here. Primarily serves as a procedural formality to acknowledge that a bill has now in existence and initiate its journey. Second reading. This is the first major hurdle for the bill. A full-fledged debate delves into the bill's principles, merits, and potential implications. A majority vote in favor is required for the bill to proceed to the committee stage. The government holds significant advantage in this particular area in securing support at this stage due to party discipline in whips, because in the Houses of Commons, the whips force the MPs of their party to side with the party line rather than to cross floors. It is considered a very bad thing to do. It can be a political career-ending move. And the whips ensure that indeed, if the parliamentarians do cross the floor, then their legal right to be not legal, I am mistaken here, that it would not be an easy journey for them in their political life from that point on. At step 3, we have the committee stage. The bill undergoes line-by-line scrutiny. This is a very detailed reading, and here a lot of the debate happens, often made up of MPs or lords with relevant expertise, usually MPs or lords who are lawyers, barristers, or solicitors in their own right, or maybe engineers or anything related to that field will be added to the committee, and they will actually review the law in as greater detail as they can. Amendments can be proposed and debated at this stage, potentially altering the bill's content significantly. Public bill committees may hold public hearings and receive written evidence to inform their scrutiny. This stage plays a crucial role in refining the bill and addressing concerns and finding consensus. The reporting stage, the House reconvenes to consider amendment made in committee stage and vote on them. Further amendments can be proposed to this at this stage. This stage provides an opportunity to review and refine the bill based on committee deliberations. The third reading, if approved at the report stage, if approved at the report stage, okay, approved at the report stage, the committee will vote on them. Further amendments can be proposed at this stage. This stage provides an opportunity to review and refine the bill based on committee deliberations. The third reading, if approved at the report stage, the bill goes to a formal reading with potential final amendments. A final vote takes place to determine whether the bill passes the House of Lords, House of Commons, or the House of Lords. This stage marks the final hurdle for the bill within the initial House. However, if the House of Lords is in play and its powers and obligations are there, then we must remember that it cannot stop a law from being enacted indefinitely, especially money bills are beyond its power post the Parliamentary Acts of 1911 and 1949, which have significantly curtailed their authority.